Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Zedkovich of ZFZ. How are you today, Callum?
I'm good, Luke. How are you?
Good. Been very busy. We missed our Thursday drop last week, hey? We had too much going on.
I think it's the first time we've had an unscheduled missing of a session for maybe 9 months.
I think you're right. Look, I think I've got to put my hand up for a big share of that. I think over the last 2 weeks, I've arrested 2 ships in different parts of the world. One as a US lawyer, one as an Australian lawyer. So it's been a bit full on, but in a good way. You know, it's good to be busy. And yeah, keeping the pencil sharpened, huh?
Exactly, and same on my side. It's been a full on couple of weeks, but it's good to be back. Good to be checking in with what's going on in the High Court, and we've got an interesting one this week.
Yeah, I like this case. In some ways, I've got to say from the outset, and I know I'm kind of jumping right to the punchline here. This case is a shipping case for everyone listening in. Well and truly into bread and butter issues of shipping law here, dealing with off-hire and what can, or more to the point, cannot be deducted from off-hire in this particular charter party. And I'm pretty surprised we've got a High Court judgment on the point, Callum. I don't know what your take is on it, but in the context of this very bespoke clause, I thought it was bleedingly obvious what the parties were trying to achieve here.
Yeah, I agree with you. So the as is kind of often the way with these appeals on a point of law, they set out precisely the question that they want to answer, and they set it out as a yes or no question. And I read it the first time, and I thought, is that the question? And then I read it a second time, and I thought, well, the answer is yes. The answer must be yes. And then to paragraph 3, the judge says, and the answer is yes. And I thought, fair enough. They've got that right.
Exactly. Look, for everyone who loves a good citation, we're talking about the recent fast freight and bulk Trident shipping decision handed down on the 24th of January 2023. It's an English High Court decision coming out of the Commercial Court. The neutral citation number is 2023 EWHC 105 COM. And it's a decision of the Honourable Mr. Justice Henshaw. It's one of those decisions that I think it's good to go over these kinds of decisions. It's good to have them. As much as I may joke and say, I'm surprised we've got a High Court decision on the point. It's good that we do, right? It's good to be able to talk about these types of cases which go to such a fundamental issue between owners and charterers in a charter party. And that is how the payment of hire works, what deductions are allowed in different contexts, and how that interacts with the off-hire clause as well. And I think there is a macro issue here, Callum, isn't there, around the kind of tension back and forth between owners and charterers over owners wanting to make sure that they get paid their hire regularly without deductions. Charterers, perhaps, the suggestion is that there have been occasions where charterers may have made deductions from hire that are on kind of less than reasonable grounds or what have you, and more spurious kind of grounds. And there's this kind of back and forth over where to draw the line and who should be wearing the security really of those payments, right?
I've seen maybe in more recent charters more of these clauses that say that you cannot deduct from hire until that deduction is agreed. And that's maybe that's just a case of the market going a certain direction, or I mean, who knows? But I've seen in a few instances, when you're acting for charters, this is a reasonably helpful clause to rely on to say, well, let's just slow things down. Let's make sure we get this right. We don't need to agree to anything. When acting for owners, pardon me, when the charter is demanding the ship be said to be off hire, then you can say, well, hang on a minute, let's take our time, work through it, make sure that you actually have a right to deduct before you go away and deduct. So I wonder if this one maybe got through on a point of public importance, just because it does seem to be kind of fashionable to include these clauses nowadays.
I think that must have been the rationale on the permission application to get into court. I thought the legal question was relatively straightforward in the context of this particular clause, and we're going to get into that in a moment. But there is a broader point here around if you didn't have this type of clause, or if the clause was not as strident as this clause is in making it clear, I think, that charters are not allowed to deduct at all unless they have owners' consent in writing to do so for off-hire or alleged off-hire. Yeah, but it's this bigger point. I've seen the same, Callum, on these types of clauses coming into charter parties more often, and I think what it goes to is this question of security, right? It's not about the charterers losing their right substantively to deduct off-hire or make off-hire claims. They're entitled to do so. It's just that the owners are going to be in the money while that dispute is dealt with.
Yeah, exactly. Maybe a bit of background will be helpful to our listeners. So the vessel is the Anna Dorothea, and it was a trip time charter for the carriage of goods from the East Coast India to China, and it's an NYPE 1993 form with a number of additional clauses attached in the normal way. Hire was payable at a rate of $20,000 a day, every 5 days in advance. And effectively, the ship arrives and they faced a long delay. And charterers asserted the long delay was because of the COVID diagnosis of certain members of the crew. So we have one of these COVID off-hire claims. As with all of those claims, it's turning on the wording in the specific charter, but actually the arbitrators weren't looking at that question of whether or not the ship was off hire. They were simply looking at the fact that the charterers stopped paying hire from the point of alleging that the ship was off hire. They said, we're not going to pay any hire until the ship comes back on hire. And owners said, no, you have to pay hire, because when you're not entitled to make a deduction for off hire until we've assessed whether or not until we've assessed and agreed with your off hire demand. And they pointed to this clause, which said, I'll read the whole thing. Notwithstanding of the terms and provisions hereof, no deductions from hire may be made for any reason under clause 17 or otherwise, whether, and it reads whether / or alleged, and the judge said that probably meant whether for alleged off hire, underperformance, overconsumption, or any other clause whatsoever, without the express written agreement of owners at owner's discretion. Charterers are entitled to deduct value of estimated bunker on redelivery. Deduction from hire are never allowed except for estimated bunker on redelivery. And the owners predictably said, well, you can't just put the vessel off hire and refuse to pay. You need to keep paying us hire until we say, yes, fair enough, that was off hire. And the charterers said, no, these deductions only apply. These aren't deductions from hire, because to be a deduction from hire, you'd have to have some hire payable. And we say no hire is payable, therefore this is something else. This falls into a different category. It's not a deduction from hire because we're simply not paying you hire because hire is not due.
Exactly. And what did the arbitrators say? They said, well, it's pretty clear that what the parties were trying to do here was to establish a scenario where charterers had to continue to pay hire while the disputes are resolved, or of course if owners agree and they have written agreement of owners at owner's discretion to allow the off-hire deduction, then fine. But in the absence of that, charterers have to continue to pay hire. And the arbitrators went so far as to say that, it could be overkill with this last phrase, deduction from the hire are never allowed except for estimated bunker on redelivery. And I tend to agree. I think, it didn't need that sentence.
I'm trying to find exactly what the arbitrators said, but they did say something along the lines of this absolutely could not have been clearer. And if anything, it's gone too far.
Yeah, exactly. I think they said overkill. I could be wrong. I think there's reference. Let me control find. I'm pretty sure it said overkill somewhere. Yeah. The intention of this provision could hardly be clearer. If anything, it might be said to suffer from overkill, and that's in paragraph 18 of the award. Yeah, I tend to think that's right. I don't tend to think. I do think that's right. And I don't think you need the last sentence in there to make that clear or to get that clarity from the provision. Notwithstanding, now what I will say about this clause is, as was noted in the decision, it doesn't appear that it was drafted by lawyers and was probably drafted by the commercial folk that were fixing the charter. And so some of the language is a little bit off. It's not that tight. There's a typo, a couple of typos. But yeah, notwithstanding of the terms and provisions hereof, no deductions from hire may be made for any reason under Clause 17 or otherwise. So under Clause 17, that's the off-hire provision, or otherwise. Then it goes further to say whether for alleged off-hire, underperformance, overconsumption, or any other cause whatsoever. So they're trying, it's not just a narrow off-hire issue, like for underperformance or overconsumption, like you can't deduct for that. It's or any other cause whatsoever. So they're trying to capture that language from the off-hire provision to make it very clear that this no deduction from hire clause is applying under Clause 17 or otherwise, so other clauses within the Charter relating to off-hire, and any types of off-hire, basically. And then he goes on to say, without the express written agreement of owners, okay, that's one point, again, in owners' favour of this, without the express written agreement of owners, quite strong language, and then at owners' discretion on top of that. So there's 4 or 5 indications that the part in that one sentence that the parties are trying to make it quite clear that there'll be no deductions from hire. Now, this whole debate was around what does the word deductions mean? That's what charters were hanging on to, deductions. And I like the lawyering. Don't get me wrong. I like the way that, they try to come up with a debate here around what deduction means in a formal sense. But when you step back and look at the clause, as commercial arbitrators tend to do, it seems like it's pretty obvious what the parties were trying to achieve.
Yeah, and for me, so again, kind of putting Charter's argument at its highest, they were saying we can't deduct from something that's not payable. So strictly, this isn't a deduction because there is no hire payable, and all the kind of overkill language doesn't actually apply because we don't get that far. We only get to the point of the clause that says deductions from hire, and there is no deduction from hire. We're not talking about a deduction from hire. We're talking about us not paying money that is not due, and therefore that's where it all falls away. The kind of insurmountable argument in owners' favour, I think, is on this wording where they say no deductions from hire, and then in brackets whether for alleged underperformance, overconsumption, or any other cause. It's that alleged word means that they are specifically envisaging a situation where the off-hire is only alleged and not guaranteed. So it's very clear that what they're trying to do is cater for that situation where charters have a claim to off-hire, but it's not yet resolved. So I think that, to me, that was the bit when I first read it where I thought, okay, that's, they're not going to get past that particular hurdle. The other point that I think charters were making was based on the case of the lutition, which is this case that this is kind of authority for the point that if a vessel is off hire on the date that a hire payment falls due, that hire payment doesn't actually fall due. Essentially, you can push back when you have to pay hire if the ship is off hire at the time. That's a Lord Bingham decision of some time ago, but the court found it pretty easy to distinguish that case simply because the operative wording didn't exist in the lutition, but it does exist here. So each of these cases kind of lives or dies on the contract, off hire being a contractual It's a creature of contract rather than anything else. So the fact that the contracts were markedly different between the letition and the contract in issue here meant that you could reasonably easily distinguish the two. So that didn't get the charterers very far either.
Yeah, and going back to the meaning of deductions, I think what charters were trying to say is, look, if they used language like withholding, that would have been clearer rather than deducting, because you don't have, as you say, you don't have something to deduct from. So charterers said, and there is a lawyer point here around this provision. Let's assume that it has been drafted by commercial people, as was mentioned or assumed in the decision. Different words do have different meanings, and it created this debate by using language that wasn't as precise as it could have been. And you'd like to think that, if this was drafted by lawyers and gone through that kind of process, that you would have had, as hard as the parties kind of tried to make it as clear as they could by inserting a word there that isn't bang on the right word to use, potentially, it created a debate. Do you see what I mean? And
yeah, I do, but for me, it's
I read it. I can tell you now, when I read it, I didn't think there was any confusion here. I thought I can see the argument they've come up with, kind of. I just don't think it gets over all the other indicia in this particular clause that have tried to make it very clear that you can't deduct from hire, or you can't withhold from hire.
I mean, there was a lot at stake. So you can see why. I think it was slightly over 2 million at stake. So you can see why this point was pushed. And as you say, it's creative work. It's good work from the lawyers. Finding this way around it. But I think so often with these construction clauses, your kind of gut feel once you've gone through the process of doing a law degree, doing your various law courses, going through your training contract, doing a number of years kind of working in the industry, gut feel really will take you there kind of 90-95% of the time. Reading this, it was a very clear gut feel of, well, yeah, they're obviously trying to make sure that charterers can't just make deductions. Yeah, I mean, maybe it's worth just reflecting on where the law of off-hire stands currently, which is, obviously you have a tension under a charter party between one party, the charterers, who have to pay hire, and they have a very kind of clear obligation to continue to pay hire. And if they fail to pay hire, then charterers can withdraw the ship. And obviously that's a serious remedy for the owner to exercise. But if charterers fail to pay hire, then typically there's a right of withdrawal. The point where that kind of changes without the wording that we saw in this charter party is around off hire. And if there is an off hire event, then charterers are entitled to exercise a kind of good faith discretion over the amount of off hire that they deduct. There's actually, as far as I'm aware, a slight lacuna in the law in that if you're advising a charterer and the charterer says this thing happened, we're not sure if it's an off hire event, but we know that it lasted 5 days. In that situation, a charterer can't say in good faith we thought it was an off hire event. That doesn't get them home. But if you had a second type of event where the charterer says we're sure it was an off hire event, but we're not sure whether the off hire is 5 days or 10 days, then in good faith they can deduct the 10 and they're safe from withdrawal. In the first situation where you're sure of the duration but you're not sure of the event, there's a case that says actually that could still be a wrongful deduction that entitles the owner to withdraw. So there's a slight oddity in the law there. But typically, kind of as in broad brush, a charterer has a right to exercise good faith discretion when making an off-hire deduction. And these clauses, as you say, Luke, they kind of provide some security to the owner because they say, well, you can't just stretch that good faith deduction to its extreme and leave us in a position where we're out of pocket trying to chase a charterer, potentially a charterer without assets, for recovery of hire that actually was due. They say you have to pay us and then come and sue us for the balance, or alternatively come and talk to us over the balance. And that's why I think these clauses are. We see a number of these clauses in contracts now that gives some sort of background, I guess, not only to why this case is relevant and why this case had some interesting point of market principle, but also why I think the arbitrators in the court said, well, it's pretty clear what they're trying to do here. What the parties are trying to do is go back on that general legal principle of being entitled to make a good faith deduction and saying, actually, you can only make the deduction that we agree to. Otherwise, we're in the money and you have to come and fight it.
I think it's good faith and reasonable grounds, right? Is the test for whether charterers can make an off-hire deduction. And so there is this aspect of reasonableness in there as well. But you're right. And I think it comes down to what are the parties actually agreeing here in terms of allocation of risk? And it is well within parties to agree, even if it seems odd. I don't think it does actually seem odd, but even if it may commercially not seem obvious at present why charterers would agree to something like this, it is certainly possible for owners and charterers to agree to say charterers have to continue to pay hire, irrespective of any off-hire claims that they may have. Money gets paid to the owners, and then charterers can bring their off-hire claims in the usual way in arbitration. Charterers may not like that, right? And if they don't like it, don't agree to it in the first place. But in terms of allocating how a process for dealing with off-hire claims, that is certainly possible that the parties could agree to that. And it may be a bad bargain for charterers, but it can be a bargain nonetheless. And it's kind of what the court's saying here, isn't it? It's no defense to say it's a bad bargain, we don't like it. It is what it is.
And it's no worse a bargain than the normal position is for owners. I mean, in any claim, somebody has to be the one who's out of the money and somebody has to be the person claiming for it. So this is simply, as you say, Luke, at the outset, this is just a security question. Who's secured, who's in the money, and who's not, who's chasing the money. And it's pretty clear on this clause that the parties have wanted just to flip that from the normal position to one where owners sit in the money and charterers have to bring the claim against them.
Which comes on to my other question: was there much discussion of the lien rights? I think there was an accompanying lien right here. It may have just been the normal lien on the vessel for all monies paid in advance and not earned, I think.
Yeah, I think that's right.
I'd be interested to know, and we haven't got the full charter party, obviously, whether the lien language was tweaked in any way. Because you can kind of see how, if you're bolstering up the obligation on charterers to continue to pay hire throughout, that they should have some continuing lien over the vessel for off-hire claims that they may have. And, if we were advising charterers and so commercially, they come to us and say, look, this is only going to get done if we agree to this clause, this no deduction from hire clause. And what can we do? We'd be saying, well, okay, let's look at this as a security issue. And in the event that you've had to pay hire, and you have off-hire claims, what's your big concern? Your concern is getting security for that claim. Obviously, there's a cash flow issue as well, which is not good, but delays and off-hire can cause consequential issues commercially for charterers too. But ultimately, what you're worried about is the ability to get security for your claim. And so, one of the thoughts I would have is to pivot to say, okay, in the negotiations of the charter, what are your lien rights over the ship in the event of having off-hire claims? And
I've just found it in the case that so the lien clause included in the normal way, charterers shall have a lien on the vessel for all monies paid in advance and not earned. And I think that did come into the decision of the judge it's a paragraph 23 where they say that the charter is not prejudiced because it has a lien on the vessel for any overpayment. So in the same way, I kind of both are secured. And this also goes to the point that I guess typically it's easier to find a way to enforce against a ship. If you have a claim against a ship, then at least there's a ship floating around somewhere that you can have that you can raise your claim against. Whereas against a charterer, sometimes that's more tricky to get security. You need to think a little bit more carefully. So the balance of security is certainly not kind of unconscionable, or it doesn't hit any of those thresholds where you go, this is a truly awful bargain. They surely didn't mean this. But it seems pretty straightforward and sensible.
Well, I didn't have much more on this one.
No,
I think there is an interesting section. So for anyone, for anyone interested in this area, I suppose I should say, but particularly anyone new into the industry, maybe starting lawyers or what have you, it's a useful discussion in there, as you really usefully set out, Callum, around the burdens in paying hire and claiming off hire, and who bears the burdens of that. It's primarily on charterers to bring themselves within off hire clauses, and I just think it's a useful, almost like bullet point description of the landscape of hire and off hire, which is quite useful to go over.
Yeah, agreed. So paragraph 23 in particular, where the Mr. Justice Henshaw sets out in very brief, this is how off hire works, basically, which is as you'd expect, it's a very succinct and fulsome description of off hire and the general principles.
Yeah, and it's useful because that applies when you don't have a bespoke clause like this.
Yeah.
Which will be often the situation. So, look, I hope you enjoyed today's episode, everyone. Thank you for coming back after the week hiatus. We hope you've enjoyed today's podcast, and thank you for listening in. And until next time, take care. Oh, by the way, if you enjoy these, if you want to support us and help build up our profile, please do follow us and subscribe on the various channels. Click the like button, subscribe button, all that stuff. We'd be grateful.
Cheers, everybody.